between anthropogenic emissions by sources and removals of greenhouse gases in the second half of the century, that is by 2050, on the basis of equity and in the context of sustainable development and efforts to eradicate poverty. Now, I think I've given you a heavy dose of this climate change regime. Let me just take you through to some aspects of why this regime has created so much of confusion, and why is it not being adhered to by differing states. What are the problems really? And before I come to this, it is important to understand that what does the science say? You have a body called as the Intergovernmental Panel on Climate Change, that is the IPCC, and the latest 6th assessment report says developed countries have appropriated the global commons and their share of total carbon budget. Between 1850 and 2019, developed countries contributed 57% of the cumulative carbon emissions, despite being only 16% of the global population. It is in the light of these statistics that developing countries have been demanding that developed countries must compensate for their excessive use of carbon budget, and it is incumbent upon them to take the lead in combating global climate change and the adverse effects thereof. It is also felt that the compensation would also mean that developed countries undertake urgent and substantial investment in negative emission technologies to compensate their excessive cumulative emissions which they have undertaken and contributed in excessive use, or what some scholars have called as excessive misuse of the global carbon budget. It is also known that this issue of combating global climate change, one of the major impediments is lack of finances, or what is called as global finance. And this issue of climate finance is shown by a number of developed countries to be an issue which is not integral to the climate treaty regime. And there cannot be a bigger lie than this. Global finance or climate finance has been there in the UNFCCC, it has been there in the Kyoto Protocol, and it has been in the Paris Agreement. And the treaties, the entire set of treaties are unequivocal when they say that the lead and means of support and implementation has to be provided to lesser developed, developing and vulnerable small island states. If you look at Article 4.7 of the UNFCCC, it states that the extent to which developing country parties will effectively implement their commitments under the convention will depend on the effective implementation by developed country parties of their commitments under the convention related to finance, financial resources, transfer of technology, and taking into fully account that economic and social development and poverty eradication are and remain the first and overriding priorities of developing country parties. As is commonly known, the first effort to provide any form of global finance was made at the Copenhagen COP in 2009, where countries had pledged $100 billion annually for developing countries and lesser developed countries. However, it has been seen that in the period 2019 to 2020, if you look at an estimate, it says the annual provision has not been more than 40.2 billion. It's literally 60 billion less. And even in this amount that has been provided to developing countries has not been through grants, but it has largely been through loans and investment measures. Now, these loans and investment measures have been, opposed by developing and poorer countries because they have argued that they are unable to repay the loans lent to them by World Banks and other international financial institutions, And there is a possibility, a great possibility, that they will be caught up in a debt trap while repaying these loans, which they desperately require for their own developmental activities. The Paris Agreement, as I said a while ago, it provides for what is called as new and additional financial resources. And a report of the Standing Committee of Finance that came up, last year, it says the requirements are a whopping amount of 5.8 trillion US dollars compared to the $100 billion that were pledged in 2009. And this may go much more than that, to close to 11.5 trillion annually. Now, this large amount that is required to meet the needs of developing countries to combat climate change does not actually, reflect all of their developmental needs. Now, there is an expectation that the next COP that would be held in next month in Baku, Azerbaijan, it is billed as a climate finance COP. And the Azerbaijani government and other countries, are expected to reach a conclusion on what is called as the new collective quantified goal. It's often called as the NCQG on climate finance, new collective quantified goal on climate finance. And developing countries have demanded that this new climate finance would provide a definition of what would be constituted as climate finance. The quantification of this climate finance also needs to be decided upon. This finance should be public sourced. It should be from governmental sources. It should be grant based, not in the form of loans, or it should not be in the form of investment measures. It should be from the public resources. Supplementary help, of course, can be provided by multilateral developmental banks and other financial institutions. But the main finance should come from countries and not from international financial institutions. This was also, very clearly told by, our own Prime Minister at COP28 when, PM Narendra Modi spoke of climate justice. And he said that principles of equity and climate justice demand that historical emissions as well as the world's carbon budget are equally distributed. And I quote what he said. He said, India is striking a balance between economy and ecology. We have 17% of the world's population but contribute less than 4% of the global carbon emissions, unquote. So there exists a glaring inequality in the distribution of per capita emissions of different parts of the world and regions. There is also a new phenomenon, I'm sure those of you who read newspapers would have found out, which is called as declaring your net zero emissions targets. Now India has pledged its target to be 2070. There are a number of other countries. China says 2050, but according to the global summit as well as the sustainable development agenda as well as what has been achieved from the last three COPs, from Glasgow, Sharm el Sheikh, Dubai, and the one that is going to be held in Baku next month, developing countries have been demanding that this global peaking period for developed countries should be much before 2030. And after 2030, they should, have complete, net negativity of their carbon emissions. Simply because, this global sustainable agenda that was adopted recently by the General Assembly also speaks the same. It adopts what is called as the global stocktake output that came up, in the last Dubai COP. In 2023. Now, developing countries have also been demanding that you cannot have a uniform net zero emissions target for all, simply for the reason that this net zero emissions, not only it needs to be staggered, but this peaking point for developing countries would be later in time as compared to, developed countries whose use of the carbon is much earlier, so they would naturally peak much earlier. So you cannot have one single, uniform peaking time or a net zero emissions target for all countries. India, to speak a word or two of, India, one can't deny that, India has been facing the wrath of climate change. In our own country, you witnessed what happened in Wayanad in Kerala, in Uttarakhand and Himachal Pradesh last year. Many parts of the northeast were affected by the adverse effects of climate change. In fact, India has been facing loss of vegetation, change in hydrological cycles, extreme heat waves which were witnessed in Delhi and many other parts of India, and also rising sea levels which have affected lives and livelihood throughout the country. India has submitted NDCs for the period 2130 under the Paris Agreement, and we have put in place a national action plan for climate change which is called as a NAPCC. And to be very frank, India is much ahead than many other developed countries in undertaking their climate change obligations. Considering the fact that and our population and our needs to combat and eradicate poverty, I think India has done a stellar job, not only in achieving many targets. To just list a few of this, it has achieved 33% reduction in emission intensity of its GDP between 2005 and 2019, and has hence achieved this target 11 years in advance, which was to be achieved by the year 2030. It has also enhanced its target to 45% in the enhanced NDCs which we have submitted in 2022. India has put in place a long-term low emissions development strategy, and we have submitted this to the UNFCCC Secretariat in November 22. Unlike many other developed countries, India has taken bold, strong domestic actions to combat climate change. Even on the multilateral front, India has taken a lead to support greenhouse gas related international organizations, and there are at least 4 of these in recent times. One is the International Solar Alliance, then you have the Coalition for Disaster Resilience Infrastructure called as CDRI. You also have something called as the Leadership Group of Industrial Transition called as LED-IT, which helps small island states and lesser developed countries. And recently at the G20 meeting, India also adopted the Global Biofuel Alliance, which would exploit biofuels, facilitating technology advancement and intensifying use of sustainable biofuels. Coming to the last part of my lecture, I think it needs to be looked at that the global legal architecture needed to combat climate change is already in place. I think what is lacking is the resolve from developed country parties to provide sustained, committed, and equitable climate finance to developing countries, as has been provided under the UNFCCC and the Paris Agreement, and abide by these obligations in good faith, as has been pointed out by a number of decisions of the International Court of Justice and a number of other tribunals. These inconsistencies in taking strong climate action by developed countries is not only a matter of grave concern, but also it also shows a complete lack of culture of compliance in the world today which we see. And this has led to some of international law scholars to call international law primitive in nature. While the law on the subject is very clear, I think the politics of climate change is more fascinating and is also more difficult to gauge and understand. You have a large number of developing countries. You have a large number of small island states. You have a small group of developed countries. Take for example the G77. Even in the G77 you have a number of grouping of countries who have varied interests. You have Saudi Arabia led, say the Arab group, they are fossil fuel producing countries. Their interests are different from entire Africa who don't produce any fuel. They have stronger developmental concern. You have small island states which climate science says that they can be sinking, and they require urgent what you say help to see that not only for resettlement but also for literal sustenance and survival. And amongst these you have a large number of like-minded developing countries group, LMDC countries group, led by Bolivia, Brazil, and India also being a part of that. You have basic countries, you have BRIC countries, you have Argentina, Brazil, Uruguay, ABU group of countries, you have the EU, you have the environmental integrity group, Switzerland, Austria and others. You have JUSCANS, Japan, US, Canada, New Zealand. A number of these groupings, each of them has different understanding of environment and development. So some of these, the negotiations which go on, not only do they get dragged, not only do they become slow, but they become very cumbersome, very protracted because of difficulty in reaching textual agreements on a number of topics. And one of the main topics where there has been dragging of feet by the developed countries is climate finance. Simply because a large number of these countries say, so what that we were the major polluters of the world, so what that we have developed early, so what that the industrial revolution came to our part of the world much before it came to other parts of the world. But today we don't have the amount of money developing countries are asking to meet their needs of combating climate change. Now this issue has reached a flashpoint. It has reached a point where your actions or any form of actions you take in combating climate change is directly proportional to the means of support that is to be provided to you by developed countries. So the definition and agreement of climate finance is something which I think is of primary interest. It is also to be seen that there are a large number of small island states, as I just mentioned, who have expressed deep amount of lack of faith in the multilateral process. They are disenchanted with diplomatic negotiation and operation of the multilateral regime on climate change. And these group of countries have been forced to approach international judicial bodies and tribunals for some form of judicial approbation of the application and interpretation of existing climate change laws. Now there are three such advisory opinions that have been sought. One is by Chile and Colombia, which went before the Inter-American Court of Human Rights, asking an advisory opinion on what are the human rights aspect of climate emergency. The second one was a group of countries called as COSIS countries, small island states. They requested the ITLOS last year, and ITLOS came up this May with its advisory opinion. This advisory opinion, and the third one is of course the one before the ICJ, which the General Assembly through resolution 77-276 has been requested to provide its opinion what is called as obligation of states in respect of climate change. Now, although the three advisory opinions appear similar, I think what states are asking is what is the judicial view on impacts of climate change. Everybody knows what the impacts of climate change are. And everybody also knows that once the advisory opinions come out, many of them, although they are authoritative judicial pronouncements on what international law ought to be or what international law is on the subject, countries would again drag their feet, and it is for countries and states themselves to implement this international law. Countries don't implement international law because the World Court says that. Countries would implement climate change obligations if their pockets allow them to do. So you have not only good faith. People would also go on to say that countries would implement many of these obligations not only because of lack of finances, but also because of lack of trust. You have any number of environmental law principles on public trust doctrine, on what you say, global planetary obligations, but many of these writings seem very of academic interest. you know if you look at the global climate change problem, it largely comes down to brass tacks as to whether you have the finances to undertake deep cuts in your greenhouse gas emissions. So on the positive side, Ambassador Erickson would bear me out. This ITLOS opinion has it has stated that ocean acidification would also be included in the definition of marine pollution as has been provided in Article 1 of the Law of the Sea Convention. It says anthropogenic greenhouse gas emissions into the atmosphere constitute pollution of the marine environment within the meaning of Article 1, Para 1, Subparagraph 4 of UNCLOS. It also goes on to say that the scope and content of necessary measures may vary, bearing in mind states' capabilities. This is the word UNCLOS uses. But more importantly, ITLOS also states that states have the specific obligations to protect and preserve the marine environment from climate change impacts and ocean acidification. Article 1, Para 1, which speaks about different forms of, pollution of the marine environment, doesn't include ocean acidification. It doesn't include the word greenhouse gas emission, but it does include the words human-induced, activities. This advisory opinion, which would, provide some succor to the needs and the demands of small island states. Now, coming to the last part of my, on my lecture, these advisory opinions may collectively provide necessary clarifications on the application and interpretation of the treaties governing the climate system, apart from persuading states to abide by international law. However, at the end of the day, it's the responsibility of states to implement their international obligations in good faith. As the ICJ has attested to this fact in a number of advisory and contentious decisions, this faith must be based on the realization that carbon space we all live in is finite, and we need unity of purpose to ensure the well-being of planet Earth. Last month, the General Assembly again took up the cause of climate change when the Summit of the Future Pact in Action Point 9 read, "We will strengthen our actions to address climate change." It is hoped that world leaders meeting in Baku next month would show leadership and strength of character and devote their energies to reach a collective agreed definition of climate finance, and will agree to the much needed more than $4 trillion a year, $4 trillion a year, to meet the needs of developing countries and small island states. In conclusion, I believe a true homage to Professor Rehmatullah Khan's legacy and contribution to the subject of international law can only mean that his students who knew him carry forward his legacy with the same zeal and spirit in which Professor Khan lived his life and taught passionately and selflessly without seeking any accolades or position. I dedicate this lecture to his memory and believe that this lecture would be a small token of contribution to the understanding of the subject of international environmental law, which he so beautifully taught us. Also hope that this would in some measure add voice to the cause of the development of international law towards achieving a just and equitable legal order, especially in the efforts of developing countries and of course individuals of all countries to protect the global climate for present and future generations. I thank you.
Thank you, Dr. Rangreji, for that illuminating lecture and for sharing your wisdom with us. I now invite Professor Suprita Acharya, Assistant Professor and Assistant Dean, JGLS, to deliver the concluding remarks.
Hi everyone, good afternoon. I would like to begin with a caveat. The caveat being that I'm not an international law researcher. However, these are my reflections with limited understanding. It may not be as intellectually sharp as the dignitaries who spoke before me, but interesting enough, or so I hope. When I first heard Professor Rehmatullah Khan's name, I thought to myself that this name has a very poetic ring to it. It has textures of a very loud, emphatic utterance one would claim for oneself when in anguish. I was pleasantly surprised months later, as I was browsing the web to understand his corpus of work, that the fourth Google search result takes us to a Urdu poet going by the same name. I became curious, clicked on this link by a website called Rekhta that collates shairis, and the first shairi that I stumbled upon was "Ik sira ulझी हुई डोर का हाथ आया है, दूसरे तक भी पहुंच जाऊंगा सुलझाते हुए," which means to say that the beginning of a cord that has reached my one hand is quite entangled. However, by the time it reaches the second, it will become disentangled. This gives us a very optimistic approach to life. It has strong brush strokes of hope and perseverance housed in it. My understanding of Professor Rehmatullah Khan's life and works posthumously paints a very similar picture for me. I quote from an eulogy I stumbled upon that informs this understanding of mine. It goes to say that his works developed and stood the odds of the perceived absence of textual tradition and epistemological narrowness accusation for international law scholarship in India. Against the constraints of his times, he bred the earliest epistemic culture in international law from India, along with his contemporaries, including Hiralal Chatterjee, Nagendra Singh, S.P. Sinha, R.P. Anand, and others. His works were also symbolically relevant not only for academic scholarship, but one that conditioned Indian state practice on issues like globalization, international trade law, warfare, and others. Professor Khan had a rich scholarship that encompasses 50 research articles, 6 books, 3 edited volumes, and 4 monographs. His contributions include works on implied powers of the UN, UNGA's peacekeeping powers, guerrilla warfare, international law, Kashmir, NIEO, UN and international conflicts, anti-globalization protests, and International Tribunal for the Law of the Sea. A lot of these works date back to the 1960s, when internet and online resources and open access journals were not easily accessible. And even when they were easily accessible, the access was quite limited and was in rudimentary form. These struggles are commendable. The struggles that one researcher back in the 1960s faced to publish, and these struggles are also lost on us, given that we are not usually used to and in access to internet. It's equally pertinent to note the involvement of Dr. Luther Rangreji, who I would like to thank today for finding the time to visit our campus and deliver the lecture. We are extremely grateful for your presence here. As a parting note, Professor Khan, in one of his last lectures that he chaired at South Asian University, mentioned that he started his career in 1962, and throughout his career, his goal has been the pursuit of academic and intellectual excellence. Despite his achievements, he says that he was quite reticent towards utterances of self-proclamation. He was not very interested in talking about himself, but rather getting to know the students more, engage with them, and field their questions. I think these were not just mere words said for effect. These are also sentiments that translated and morphed into his lived experience. Past accounts of former students mention that Professor Khan used to publish his books through local Indian publishers so that his writings can be accessed by students, scholars, and libraries affordably. This speaks volumes about not just the legacy and the personality embodied by Professor Khan, but also very telling and reflective of the positive disposition that he bore as a teacher who's always invested in magnifying the light of his students. Thank you very much. Have a great day.
Thank you, Professor Acharya. I would now like to request Professor Patnaik to present our honorable guest with a memento. I would also like to invite Professor Erickson to present Dr. Rangreji with his book Liber Amicorum in honor of a modern Renaissance man. We would also like to invite Professor Chimney on stage. Before we conclude this remarkable event, it is my privilege to deliver the vote of thanks. First and foremost, I would like to express our heartfelt gratitude to Dr. Luther M. Rangreji for delivering such a thought-provoking and timely lecture on the global climate crisis and the role international law plays in addressing it. Your insights have inspired us to think deeply about our legal responsibilities towards environmental protection. A special thanks to Professor Dabiru Sridhar Patnayak, Dr. Khushbu Chauhan, and Dr. S.G. Srijit for your reflections on Dr. Khan's work. Your words have reminded us of Professor Rehmatullah Khan's profound impact on the field of international law. We are deeply grateful to our distinguished guests, faculty members, and students for your presence and participation today. Your engagement in such discussions is what fosters intellectual growth and meaningful action. Lastly, I would also like to thank the organizing team, AV, IT, FMO, events, and photography teams for their efforts behind the scenes to ensure the success of this event. Thank you all for joining us today. We hope that the ideas exchanged today will continue to resonate as we work towards a future where international law protects both people and the planet. With that, we conclude today's program. Thank you and have a wonderful day ahead.